These are some frequently asked questions about the California Constitution, Article 6. How many sections does Article 6 have? This article contains 23 sections. What does Article 6 relate to? It relates to the judicial branch of California state government. Who is given the judicial power of the state? Section 1 of Article 6 provides that the judicial power of the state is vested in the Supreme Court, the courts of appeal, and superior courts, all of which are deemed courts of record. Who composes the state Supreme Court? Section 2 provides that the Supreme Court consists of the Chief Justice and 6 associate justices, and it also provides that agreement of 4 judges present at the oral argument is necessary for a judgment. How do the courts of appeal operate in California? Section 3 provides that the legislature must divide the state into districts, with each containing a court of appeal with 1 or more divisions, and that each division consists of a presiding justice and 2 or more associate justices. Agreement of 2 judges present at the argument is necessary for a judgment. Who provides for the state's trial courts? Section 4 provides that in each county of the state, there is a superior court of 1 or more judges, and that the legislature prescribes the number of judges and provides for the officers and employees of each superior court. How are superior courts operated in the state? Section 4 provides that in each superior court there's an appellate division, and that the Chief Justice assigns judges to the appellate division for a specified term. Who comprises the Judicial Council? Section 6 provides that the Judicial Council consists of the Chief Justice and 1 other judge of the Supreme Court, as well as 3 judges of the Courts of Appeal, 10 judges of the Superior Courts, 2 non-voting court administrators, and any other non-voting members as determined by the voting membership of the Council. Each of them are appointed by the Chief Justice for a 3-year term, pursuant to any procedures that are established by the Judicial Council. 4 members of the State Bar are appointed by its governing body for 3-year terms as well, and 1 member of each house of the legislature is appointed as provided by those respective houses, the Assembly and Senate. Who staffs the Judicial Council? Section 6 provides that the Council appoints an administrative director of the courts, and this individual serves at its pleasure and performs functions delegated by the Council or the Chief Justice, other than adopting rules of court administration, practice, and procedure. Who comprises the Judicial Appointments Commission? Section 7 provides that the Commission on Judicial Appointments consists of the Chief Justice, the Attorney General, and the presiding justice of the Court of Appeal of the affected district. If there are 2 or more presiding justices, the one who has presided longest, or when a nomination or appointment to the Supreme Court is to be considered, the presiding justice who has presided longest on any court of appeal. Who comprises the Judicial Performance Commission? Section 8 provides that the Commission on Judicial Performance consists of 1 judge of a court of appeal and 2 judges of the superior courts, each of whom are appointed by the Supreme Court, as well as 2 members of the State Bar of California who have practiced law in the state for 10 years, each appointed by the governor, and finally 6 citizens who are not judges, retired judges, or members of the State Bar, 2 of whom are appointed by the governor, 2 by the Senate Committee on Rules, and 2 by the Speaker of the Assembly. What is the State Bar? Section 9 provides that the State Bar of California is a public corporation, and that every person admitted and licensed to practice law in California is a member of the State Bar, except while holding office as a judge of a court of record. Who presides over habeas corpus actions in the state? Section 10 provides that the Supreme Court, the Courts of Appeal, Superior Courts, and their judges have what's called original jurisdiction in habeas corpus proceedings. Which courts have original jurisdiction in specified matters? Section 10 states that all of the courts have original jurisdiction in proceedings for extraordinary relief in the nature of mandamus, certiorari, and prohibition. Also, superior courts have original jurisdiction in all other causes. Who reviews death penalty sentences? Section 11 provides that the Supreme Court has appellate jurisdiction when the judgment of death has been pronounced. Who determines the civil cause or civil case jurisdiction? Section 11 specifies that when appellate jurisdiction in civil cases is determined by the amount in controversy, that the legislature may change the appellate jurisdiction of the courts of appeal by changing the jurisdictional amount in controversy by statute. Can the state Supreme Court transfer certain cases? Section 12 provides that the Supreme Court may, before rendering a decision, transfer to itself a cause in a court of appeal. It may, before decision, transfer a cause from itself to a court of appeal, or from one court of appeal or division to another. Additionally, Section 12 provides that the Supreme Court may review the decision of a court of appeal in any cause. What's the test for a trial court error to result in some form of reversal of the decision? Section 13 provides that no judgment may be set aside or no new trial is granted in any cause on the ground of misdirection of the jury or the improper admission or rejection of evidence, or for any error as to any matter of pleading, or for any error regarding a matter of procedure, unless, after examination of the entire case, the court is of the opinion that the error complained of has resulted in what is called a miscarriage of justice. How is a court opinion determined to be published? Section 14 provides that the legislature must provide for the prompt publication of the opinions of the Supreme Court and the courts of appeal as the Supreme Court deems appropriate, and then those opinions must be available for publication by any person. What are the requirements for being a judge in the state? Section 15 provides that a person is ineligible to be a judge of a court of record unless for 10 years immediately preceding selection as a judge, that person has been a member of the state bar or has served as a judge of a court of record in the state. What are retention elections for appellate judges? Section 16 provides that judges of the Supreme Court may be elected at large, and judges of courts of appeal must be elected in their districts at general elections at the same time and places as the governor of the state, and their terms are 12 years beginning the Monday after January 1 following their election. What are the elections for trial court judges in the state? Section 16 provides that judges of superior courts are to be elected in their counties at general elections. And for vacancies, the governor fills vacancies in those courts by appointment. A nomination or appointment by the governor is effective when confirmed by the Commission on Judicial Appointments. What is a judge prohibited from doing in the state? Section 17 provides that a judge of a court of record may not practice law, and during the term for which the judge was selected will be ineligible for public employment or public office other than judicial employment or judicial office. Now, are there exceptions to outside employment prohibitions for judges? Section 17 specifies that a judge of a court of record may accept a part-time teaching position that's outside the normal hours of his or her judicial position and that doesn't interfere with the regular performance of his or her judicial duties while holding that judicial office. When is a judge disqualified? Section 18 provides that a judge is disqualified from acting as a judge without loss of salary while there's pending an indictment or an information charging the judge in the U.S. with a crime punishable as a felony, or a petition to the Supreme Court to review a determination by the Commission on Judicial Performance to remove or to retire a judge. Now, how is a judge disqualified? Section 18 specifies that the Commission on Judicial Performance may disqualify a judge from acting as a judge without loss of salary upon notice of formal proceedings by the Judicial Performance Commission, charging that judge with judicial misconduct or disability. When is a judge suspended? Section 18 states that the Commission on Judicial Performance must suspend a judge from office without salary when in the United States the judge pleads guilty or no contest or is found guilty of a crime punishable as a felony under California or federal law, or of any other crime that involves moral turpitude. What is the jurisdiction of Judicial Performance Commission? Section 18.1 provides that the Commission on Judicial Performance must exercise discretionary jurisdiction with regard to the oversight and discipline of so-called subordinate judicial officers. And those are according to the same standards and subject to review upon petition to the California Supreme Court. What must the Judicial Performance Commission actually provide? Section 18.5 specifies that upon request, the Commission on Judicial Performance must provide to the governor of any state of the union the text of any private admonishment, advisory letter, or other disciplinary action that the commission deems necessary to full understanding of that commission's action when a judge is an applicant that the governor of any state of the union indicates is under consideration for a judicial appointment. Who provides for judges' compensation? Section 19 specifies that the legislature must prescribe compensation for judges of the courts of record in the state. Who provides for judges' retirement? Section 20 specifies that the legislature must provide for the retirement of judges of the courts of record due to age or disability. Are temporary judges permitted in this state? Section 21 provides that upon stipulation of the parties, a court may order a cause to be tried by a temporary judge who's a member of the state bar who is sworn and empowered to act until final determination of a case. And finally, are subordinate members of the judiciary permitted? Section 22 provides that the legislature may provide for the appointment of trial courts of record of officers such as commissioners who are charged with performing so-called subordinate judicial duties in this state.